Hey, welcome to the First Time Home Buyer Workshop. I'm a former planning director for a small town and an independent real estate broker with about 20 years of urban planning experience and 20 years as a real estate broker. I have helped so many home buyers and I've answered a lot of questions posed slightly different ways. During the pandemic, I really thought about how could I help first-time home buyers, recognizing first-time home buyer remorse year over year is well over 50%. I got busy and I developed a few products, and I think they will help you in your home buying journey. Now, everyone is different and they're at a different stage, a different income level, so I didn't want just paid products. This channel hosts free content and you will learn so much here if you have the dream of owning a home. And after owning 3 houses, I can say it's well worth it. I just wish someone helped me along the way. If you go to our website, you will find a free mini class, which we don't cover anything on our website here, but that free class explains who does what, why, when, where, and how. It's called Home Buying Chaos Unwrapped. A lot of people believe the computer algorithm of get pre-approved, find a house, make an offer, go to closing, and well, that's the beauty of about a 20-second algorithm explaining how to buy a house. But there's a whole lot more than 20 seconds. Then we have our paid course called the First Time Home Buyer Workshop with Julie Marion. And this is a streamlined course of 6 lessons, worksheets, case studies, and everything the algorithm doesn't say to help you negotiate the best price, find the right home, and avoid home buyer remorse, which is well over 50% annually. Stick around here and we will give you nuggets and nuggets of home buying knowledge that are also good to know. I hope you start listening and realize that there's a lot of knowledge you need. And you don't want to do this when you're buying your home. You want to do it when it's still a dream, or at least 6 months down the road. So today we're speaking of a legal area called Freehold and Non-Freehold Estates. And it might seem boring until it's not. As always, I'm not an attorney. I'm offering this as a real estate broker and as an urban planner. This term estates, well, there are a lot of estates. And as far as the hot topics for the quote unquote estate or any trust you may be developing. So let's assume that you're at the beginning of your wealth earning years, and most likely any applicable laws or the purse or the box or the bag entitled estates and trusts. And people may say to you, oh, well, just look at that in about 5 years after you've bought your first house. But I say, let's get a base knowledge going, and that brings us to the basic understanding of freehold and non-freehold estates. A freehold estate is an interest in which anyone has in real property, meaning it's a type of property ownership where the owner has full rights to possess, use, dispose of the property as they wish, subject to any laws or regulations that may apply. So that would be your local, state, and federal laws, or anything you agree to. For example, when you buy your house, you own it, but there's a lien on the property, meaning the bank that you borrowed the money from, they put a lien on your property until you pay them back, and then they will release your lien. That means that's what I'm speaking of when I say anything that you agree to. Another example is that from day one, whenever you release title to the property, you must pay your local, state, and federal taxes. And if you do ever get sued or a creditor files a judgment against you, you may have to pay that entity back as well, or you could lose the house depending upon the circumstances. It's highly unlikely losing your house to a creditor, but we will cover that a little later and defining the circumstances around that type of activity. First, we're going to tackle freehold estates. Let's say you buy this house and you have an interest in the property. Well, there are 3 commonly accepted types of estates. They are fee simple, a fee simple determinable, fee upon condition, a life estate, and then there's estate for years, and there's a couple of others as well. But let's just tackle these. I'm going to give you some hypothetical scenarios because I think it's easier to apply them, and then we don't get confused with legal terms and jargon. So we just want to keep this simple. So fee simple absolute. This is the highest form of ownership interest, the most comprehensive, where the owner has complete control over the property and can use it, sell it, or pass it on to their heirs. There are no limitations on the duration or the use of the property, except for local zoning laws. And we'll cover that in an urban planning section of this content piece. For each of these estates, let's use this scenario for the different types of estates we're going to talk about. And then we'll give an example based on the state we're talking about. So the scenario is this. John owns a large estate called Green Acres, and he wants to plan for his future ownership and use. Under the example of fee simple, John decides to grant a fee simple ownership of a portion of Green Acres to his son, Michael. Under the fee simple absolute ownership, Michael now has complete unrestricted ownership of that portion of the estate. He can use it, sell it, or pass it on to his heirs without any conditions. Simple, right? So what are the pros and cons, you ask? Well, here there are a few to explore. A pro is that the complete and total control. The owner has the highest level of ownership, and they can use it or transfer it without restrictions, as I just said. It's a good potential long-term investment. A fee simple ownership allows for a potential appreciation of property value over time. And of course, in real estate, there are cons. And the cons would be you're responsible for all the liabilities. The owner bears responsibility for those liabilities, such as taxes, maintenance, and legal issues. There is also a risk of loss. Since the owner has full control, they also bear the risk of loss of depreciation or the loss of property value. Then there is Fee Simple Determinable. This is a type of fee simple estate where the ownership is subject to a specific condition or use. If the condition is violated, the ownership automatically terminates and the property reverts back to the grantor or their heirs. The duration of the estate is tied to the occurrence or non-occurrence of a particular event or condition. It's an automatic termination. So an example of fee simple determinable is, say there is a university granted land to a local school district, and as long as it's used for educational purposes, it's fine. If the land ceases to be used for educational purposes, the ownership automatically reverts back to the university or its successors. So let's think about this from our initial example for fee simple determinable. So here we are back again with Green Acres. John grants a section of Green Acres to the town for a public use, for a park, let's say. And that condition must always remain a park. If the town decides to use the land for any other purpose, it automatically reverts back to John or his heirs. Of course, there are pros and cons of fee simple determinable, and the pros would be that the automatic reversion, if it's a specified condition is violated, the ownership automatically reverts back to the grantor or their heirs without the need for legal action. There is clarity and certainty. The condition is typically clear, it's clearly defined, providing clarity and regarding the circumstances under which the ownership may revert back. Now, being married to a historian who examines documents from the colonial period, this in my mind is a wild card, folks. Life and society changes, so clearly defined, in my opinion, would be really tough. The cons are that there is a potential loss of ownership. The grantee may risk losing ownership if they fail to comply with the condition, even if the violation is unintentional or minor. There's limited flexibility. The grantee's use of the property may be restricted by the condition, limiting their ability to adapt and change in circumstances. And also, what about the money you put into the structures that you allowed to have these things installed on the piece of property? Think about this in this scenario. And in this particular example, I'm thinking about jungle gyms and that kind of thing. All right, so now let's go on and talk about fee upon condition. It's similar to fee simple determinable, and this type of state involves ownership that is subject to a condition. However, unlike the fee simple determinable, if the condition is violated, the grantor has the option, but it's not automatically the right to repossess the property. The grantor must take affirmative action to reclaim the property. So, for example, a grantor may convey land to a grantee, but with the condition that if the land is not used for agricultural purposes, let's say, the grantor has the right to re-enter and retake possession. So in our example, fee upon condition, John grants a portion of Green Acres to a local nature conservancy with the condition that it must be maintained as a wildlife habitat. If the conservancy fails to meet this condition of ownership, the land reverts to John or his heirs. Or say a part of the parcel is conveyed to the conservation organization, but with the condition that if the land is ever used for commercial development, say a milk stand, the homeowner or their heirs have the right to re-enter and reclaim the ownership. So the pros and cons of this type of estate, the fee upon condition, the pros would be you are able to impose specific conditions. The grantor can ensure the property is used or maintained in a certain way as for like the conservation or the preservation purposes. Also, you have the potential of reclaiming ownership. The grantor retains that right to reclaim the ownership if the conditions are not met, providing the level of control over the property's use. A con is that you're going to risk legal disputes if the conditions are not clearly defined or subject to interpretation. It may lead to the legal disputes between the grantor and the grantee. There's limited flexibility. The grantee's use of the property may be restricted by the conditions imposed by the grantor, limiting their ability to utilize the property for other purposes. So something to keep in mind is that life is fluid. Nature doesn't always want to agree with a legal document. And again, socioeconomic conditions too impact those things, as do flooding and fire come to mind as well. So there's other things that are involved in this type of thought analysis. Then there is another type of estate called a life estate. This type of estate grants ownership rights for the duration of someone's life, typically the life of the owner or another person specified in the deed. Once the life tenant dies, ownership reverts to the original owner or passes to a remainderman that is designated in the deed. So in our example of John and Green Acres, John grants a life estate in the farmhouse on Green Acres to his elderly Aunt Diana. Diana now has the right to live in the farmhouse during the duration of her life. However, upon her death, ownership of the farmhouse will pass to John's niece, Saritha. And of course, the pros and cons of life estates would be that the pro is there's assurance of housing for the life tenant, and they have the right to occupy this property during the duration of their life, providing stability and assurance of housing. Maybe there was a scenario where his Aunt Diana rescued him from homelessness and paid for his schooling, and then he made his way in the business world and bought the estate from his aunt with the condition that she would always have a place to live. Another potential is this is a potential for estate planning. Life estates can be used as a tool for estate planning to transfer property to heirs while allowing designated individuals to use their property for their lifetime. And of course, there's cons, right? And the cons are that there's going to be limitations on the property use. The life tenant's use of the property may be restricted, such as being unable to make significant alterations or improvements without permission. And there's an uncertainty for the remainderman. The remainderman must wait until the life estate terminates to gain full ownership, which may result in uncertainty or delays in accessing the property. The other con is that all of us urban planners are reminded of there was a British mother and son, and they granted a life estate to his mom so she would always have a place to live. And in the end, well, he died first. Then there is something called a remainderman estate. And the remainderman estate is an interest in land that becomes effective after the termination of a prior estate, such as a life estate or a fee simple determinable estate. When the prior estate ends, the remainderman remains and they become the possessor. This remainderman has the future interest in the property that becomes the possessory upon the happening of a certain event. Now, it all sounds similar to the life estate, but let me clarify here. A remainderman estate is the person who will inherit the property after the life estate is dissolved. And a life estate is usually a residence that a person owns for the duration of their life. So you're getting to know me now because, of course, remainderman estates have pros and cons. And the pros are that the future ownership rights, the remainderman has future interest in the property, ensuring that they will gain full ownership upon the termination of the prior estate, like we've been saying. There is potential for appreciation. The remainderman may benefit from an increase in property value during the duration of the prior estate. There is no compensation for the previous person. It just transfers. Now, the con is that there is dependence upon the prior estate. The remainderman's ownership rights are dependent upon the termination of the prior estate, which may result in uncertainty and delays. There's a lack of control until the prior estate terminates. The remainderman has limited control over the property as a life tenant or holder, because the life tenant or holder retain primary ownership rights. At the beginning of this discussion, we were defining estates with respect to ownership. And there are also estates called non-freehold estates that are temporary. So a non-freehold estate is also known as a leasehold estate. Unlike freehold estates, which have an indefinite duration, non-freehold estates, they have a finite term. Overall, the non-freehold estates provide tenants with flexibility to use and occupy property for a specific period without a long-term commitment or responsibilities associated with ownership like taxes and maintenance. However, they also come with limitations and obligations defined by the lease agreement and the landlord-tenant relationship. If a non-freehold estate, the tenant has certain rights and responsibilities as outlined in the lease agreement, but ultimate ownership and control remain with the landlord and the property owner. Non-freehold estates are really common in rental agreements for residential, commercial, and industrial property as well, and also agricultural land. There's just a lot of applications for non-freehold estates. And I think it's easiest to understand as a business leasing property for this section. Some of those key characteristics of non-freehold estates are limited duration. Freehold estates are specified for a specific period and the terms defined by the lease agreement. This period can range from months, years, or depending upon the agreement. The pros are that it's flexible. The non-freehold estates provide tenants with the flexibility to occupy a property for a specific time frame, and they may want to move. They may outgrow their area. The cons are it's uncertain. Tenants may face uncertainty about their housing or their business arrangements when leases are short-term, especially if the renewal options are not available. The financial obligation. The tenants are obligated to pay rent regardless of changes in their financial circumstances or fluctuation in property value or market conditions. You also don't earn any equity. Unlike mortgage payments where you make your mortgage payment, you get a little bit of equity for each payment. And rent, you don't get that. Then there is a lesser degree of control. While the tenant has the right to possess the property according to the lease terms, you don't really have complete control of the property. Then there are pros. Tenants are generally not responsible for major repairs on a property, like a roof or a furnace, as these obligations typically fall to the landlord. There are lower upfront costs in getting in a non-freehold estate. So that lower amount of money in order to get into housing or get into a business situation, it makes it more attractive as opposed to purchasing a property. So I hope that's giving you a broad overview of freehold and non-freehold estates. That's your 15 minutes of home buying knowledge, just another acorn to put in your home buying jar. In the next content piece, we are going to talk about liens and how they are applied. Homework. Yes, you have homework. Yes, you have homework. Your homework is to ponder how you want to hold title to your property, and you need to really start working on that budget of yours. You have been promoted to CEO of your home buying journey, and being knowledgeable is up to you. We are here to help you. Join us at the First Time Homebuyer Workshop, located at thefirsttimehomebuyerworkshop.com, with all kinds of information. Until next time, from the team at the First Time Homebuyer Workshop with Julie Marion, bye for now.